Eh, Mónica, por favor, si quieres, la idea general es que hagas una breve presentación sobre ti, tu trayectoria,
Sí.
y comencemos con la sesión. Esto obviamente es una sesión participativa, abierta, donde pues, debe haber una dinámica interactiva, ¿vale? Donde los alumnos pues, puedan hacer cuestiones, participar y podemos aprovechar al máximo estos minutos que nos has brindado. ¿Eh?
Vale. Yo la iba a hacer en inglés, no sé
En
si
inglés, en
no,
inglés.
es en inglés.
Sí, sí.
Sí. So I'll switch. I'll switch to English. So let me just introduce myself very briefly. So as you've read, my name is Monica Miglierotti. I'm originally from Italy. And I've been a lawyer for over 20 years, and a professor as well, a lecturer. I have been a civil lawyer in my home country, but I have studied and worked in the UK and in the US, and I have taught a different kind of laws, both in my mother tongue, but also in English. So I have, since I moved to Spain 8 years ago, I basically concentrated on my teaching in these subjects: legal English, legal writing, and different kinds of laws in English as well. So I'm in the process of writing a legal English book as well, using a different approach, with different materials and different sources. And I teach in different institutions, universities, and also in law firms and organizations, etc. So the purpose today of this class again is to introduce this course, also to see why, as lawyers working in an international environment, a deep knowledge of legal English, in particular, the concepts, as we will see, apart from the language itself, but also the importance of legal writing and of knowing a specific field of the law that we are specialized in English is important, for us as lawyers. Since as Borja mentioned, this is an interactive session. So Esther, I just wanted to ask you, a little bit about yourself, just very little presentation, so that I know also.
Yes, of course. Well, I am Esther Fernandez. I work in Grupo Lactalis Iberia
Mm-hmm.
in Spain. And I work at the legal department as paralegal.
Okay. I
I'm
see.
not a lawyer, but I'm paralegal. So I work with all the lawyers in this company and work always with legal documents. So,
Yeah.
and as our I don't know, our holding enterprise is in France. We
Mm-hmm.
speak with them in French and English. So
Right.
I need to improve my English to communicate properly with them.
Yes, I see. Very well. Thank you. Yes, this is the thing. And this is why, one of the reasons, one of the things that I was going to say about the importance, no, of knowing legal English when you are dealing with law from an international perspective and in an international environment, because now English has become what it's called the lingua franca, no, the Latin word of the commercial and legal world, because it doesn't matter which system we're using, the language that we use is English. Now, the thing with legal English is, though, that it's not only a matter of language, no, because the thing is that it goes together with specific concepts, and this is what, in the end, it's a little bit creates a little bit of misunderstanding at the basis of what this really is, because legal English comes from common law. No, it's related to the creation of common law in common law countries. But common law countries, when you look at the map, the world map, are just a few countries in the world. The thing is that, of course, because we need to communicate in English, and uh, you know the concepts that they have in common law relate to the specific language, in the end, we sometimes find ourselves in a position where, for example, we have a term in English that doesn't really correspond to a term in our language because they're two different concepts. So sometimes they're very similar. And this is why, you know, you need to understand, we all need to understand what they are, right? If there are similarities and differences. And this is why, you know, it's important always to have a comparative approach. And it's what I do, for example, in the classes, because, for example, you know, there are concepts that we use all the time in English, but we don't have them, for example, in our system. When we talk about consideration, we talk about bargain, etc. Those are concepts that belong to common law. Again, there are similar concepts in our system. But sometimes but most of the time we have differences. So we have to render these things in a way that everybody can understand. Problem is that, for example, when you have teachers coming from a common law system, what they do is that they will teach you common law. And so they will teach you legal English based on common law. And they don't really know civil law. So for them, it's very difficult to see how this works, for example, in Spain. But the thing is, when you have experience in both systems, then you can actually see what the difference, again, the differences and the differences in language are. Now, the thing about this is that legal English is a specific type of language as well. No, it's called a technolect. It's a technical language because it's used by people who work in the legal environment, in the legal profession. It has specific characteristics. So, for example, some words, some verbs, no, repudiation, to repudiate, to frustrate, are used in a specific way. No, when you say, for example, to enter into a contract, yeah, you enter into a contract, which is a concept that we wouldn't apply to something like this. When we enter into something, we always think about something physical, no, a building or something that we get in. But there are verbs and constructions that are specific to legal English. So, of course, we need to know how to use them, and to understand that, for example, also there are more formal, because this is the thing. Legal English is characterized by formality. That's another thing. Excessive formality, I would say sometimes, because it's traditionally it's a very formal language. Of course, when it comes to formal, there is a way of being enough formal without exaggerating, which is the normal tendency today, because now there is a thing which is called plain language movement, which is a movement advocating the simplification of legal language, no? Because this is the problem. When you think about the language, think about the fact, yes, lawyers use it, no? Lawyers use it. They have to use it in court. They use it with each other. But the problem is that legal language is actually addressed to everyone, no? Imagine the laws. The laws, the letter of the laws, we are the recipients of the laws, everyone. So we have to be able to understand them. And the fact is that because this language is so formal, it's very hard sometimes to understand what a law says. And this is why we need lawyers to interpret them, no? So now the problem is, though, that instead there is, again, this tendency to simplify, you know, this in order not to create confusion, because the tendency so far has been to make it as formal as possible. And this is the problem we also have, no, in Europe, because we have inherited, no, this for example, when we have to write a letter or a contract or something, we take templates, no? Those templates come from common law systems, and we don't really know what they refer to, because we then adapt them. But we adapt them in a way that we keep the language, no, in this contract as it is, by filling, for example, the name of the parties, the object, etc. But the problem is that most of these documents are drafted in a very complicated way, because there is a reason for that. There is a reason, because the tradition in common law is that we have a difference. This is why it's so important to know the differences between the two systems. We have a system in Europe, I mean, in civil law countries, that is called inquisitorial system, as opposed to the adversarial system that they have in common law. In the adversarial system, basically, what happens in the court is that the court itself, that is represented by a judge or a jury, etc., is just a passive recipient of information that is given by the parties. You've seen in movies all the time, where, for example, the typical example of this is American movies, when you see a criminal trial, you see that there is a prosecution on one side, the defense on the other side. They propose evidence, they propose witnesses, but the decision makers, the judge, the court, or the jury, don't really do anything. They just listen, and of course the judge is there to overlook that the rules are complied with, but they don't know beforehand. They don't know beforehand what is going to happen in the courtroom. And that's exactly the opposite in the inquisitorial system, in our system, where instead the courts, the decision makers, take an active part in the trial, because they investigate, they actually look for the truth by an activity that they have. Now, the problem about this is that because the system is so different, all the documents that we inherit from common law have, for example, clauses, contracts, for example. They have clauses which include every possible scenario. And so we have, for example, clauses that are 10 lines long without punctuation, or very little punctuation, with a lot of formal terms. And that, instead of avoiding creating ambiguity, create more confusion. And sometimes, because that's the model we have, we take it and just adapt it in our pieces of writing. But instead, we're going to learn how to be able to, even taking a template as a model, to be able to draft clauses on our own, but in a way that it's easier to understand, and that helps us avoid following problems. Because that's the purpose. I know that sometimes it's intentional. As lawyers, sometimes we do it intentionally to create confusion. But in the end, because then there must be if there is a problem of interpretation in a piece of writing, then there will be a third person, a third party, having to interpret it. So we want to avoid that, because it's always leading to a dispute. Dispute is the term that we indicate to express what a disagreement, like a legal disagreement, which is the basis then to start an action. So this is one thing. So the courses really, let's say, are all divided in what is general part, which is a part relating to everything, like about the language, about, for example, the use of Latin terms, which is very common in common law, and it's very, curiously enough, not as much as in civil law, because in civil law we have specific Latin terms, but not as much as in common law, curiously. Same thing with this formal expressions, construction of phrases, for example, in the passive, the use of these very difficult words like hereto, therein, etc., that we will see are not absolutely necessary, but if we find them, we have to be able to recognize them. Also, then we would deal with the general concepts as, for example, all the vocabulary and the concepts relating to civil procedure, criminal procedure. So who are the parties in court? What are the verbs that you use? The legal profession, again, what do lawyers do? How do you call lawyers in different countries? What are the activities that they carry out, etc. And then we will get into more, and then we will look, of course, at things, specific grammar that we need to use in legal, no, in general English, but mostly in legal, to be able to express ourselves at our best. And then we get into more specific things. So, for example, company law, contracts, which is one of the most popular areas because everybody deals with contracts, and it's a very things related to criminal law, torts, which is that's, for example, torts is an example of these differences, similarities I was talking about, because torts is the discipline of what are called civil wrongs. We don't have that in civil law. I mean, we do have something that it's called civil liability. In Spanish, it would be responsabilidad civil. But there is a totally different way of dealing with this field. And it's very interesting because it's something that concerns everyone. No, it relates to what it's extra contractual liability. So it's something that is of interest even for people who don't work in that specific field, no? And then there are like basic concepts of employment law, for example, real property, family law. But this is more to have like a wider vocabulary, and that, of course, you know, these concepts are dealt with in their basics. No, we're not going to go into specialized company law, for example, but like very basic, so that at least you have a knowledge of these concepts, plus the plus, of course, the correct vocabulary, because that's again, vocabularies on the, for example, dictionaries on the internet can be very useful, but sometimes misleading as well, because one of the things that we have to learn when we deal with formal English, and in particular legal, is to speak, of course, but also in particular write correctly. And in order to do that, there are specific rules that we have to get accustomed with. For example, punctuation. For example, the use of synonyms to avoid repetitions. The cohesion of a text, etc. We can use, again, artificial intelligence to do that. That's very easy. But sometimes, this is the problem. Sometimes, artificial intelligence, when it comes to law, can be very useful when it comes to, for example, when you have to write a letter. No, but when it comes to more complicated things, it's not. I mean, even legal GPT, and then there are other tools as well. They, for example, can cite specific cases that really don't exist. So if you rely too much on that, then you can find yourself in difficult situations as well, no? So this is the problem with these things. They can be very useful tools, but if you have a basis already of knowledge, like if you have a solid basis of knowledge, they can help you a lot. But if you just rely on those, then you can get, you can have troubles afterwards. I know of lawyers who have drafted, for example, pleadings with artificial intelligence, and they have brought them to court, and they were all the cases that they cited were non-existent. They didn't exist, for example. So yeah. So in the end, this is the thing, and it's something that can make us also much more confident in dealing with the with clients, with colleagues, because now we live in always like in a more and more international world. No, we have, it's not only a matter of national anymore. No, we have so many exchanges, and the thing is that these kind of exchanges we do with English, in English all the time. So if we're able to communicate and to express ourselves and to know what we're talking about in English, we also would be more let's say more appealing, no, in an internet, like as professionals, because if you have these skills, you obviously stand out compared to somebody who doesn't have the same skills. Now, again, it's not a matter of only speaking English correctly or quite well, but it's a matter of knowing this, the peculiarity of legal and the way to use formal English, plus to know the concepts. So this is the purpose of all these courses. So one of them is focused, again, the one that I explained is divided in two parts. It's more focused, yes, on again, on a general part and then specific parts according to specific areas of specialty. Instead, legal writing is more focused on getting to learn to write properly in English, in formal English, and of course with legal concepts. So it has, of course, references to legal English, but it's more focused on the actual writing. So, that's a lot of practice in that, no, because you have to deal with things like, for example, again, Latin terms, abbreviations, punctuation, the structure of the paragraphs, how to write a memorandum, a letter, a professional letter, even to draft a good CV, but to draft any legal document in a proper way. And that's so it's a combination of more focused on writing between legal English and formal writing. And then of course we have specific, like for example, the contract course that's focused on knowing the basic elements, of contracts, how contracts are formed, how the specific parts of a contract. I mean, although we don't really have one type of contract, because a contract can also be an exchange of letters, really can have different forms. But when it comes to traditional contracts, the ones that we use, in our practice, especially in legal offices, to be able to interpret them first, to be able to draft them, and to be able to be let's say more at ease with the language of contracts, which is the most complicated in legal, because the courtroom language is very complicated, of course, but after that there is contracts. Contracts is the field where legal English is much more complicated than any other field. So I suppose
for the contracts, I think that there are also differences between English contracts and American contracts.
Absolutely.
There are no international
No,
way to do contracts. It depends
absolutely
on the country.
Yes, but what happens is yes, exactly. But the problem is that from our point of view, being in Europe, in a civil law country, what we need to do most of the time is to, let's say, for example, depending on the other party. But imagine that you're here in Spain and you have a French counterpart. Now, if the contract is subject to one of the laws either Spanish or French. It doesn't matter, they're very similar, no? So of course you have to create a contract in English that reflects a civil law system. So that would be very different from a template that comes from the UK or the US. You can use that to a certain point, to a certain extent, but only to a certain extent. On the other hand, when you have a contract coming from the US, for example, because you have a client from the US, then you have to be able to interpret this contract to understand exactly what it says and why things are drafted this way, because sometimes, you know, they provide specific things because in their system it's like this, but it's not like that in our system. It all depends also which law governs the contract. But as you correctly stated, there is no universal, no model. This is why you need to adapt to every situation, depending on who the parties in a contract are, no? So, but because you have to do it in English, then you have to be able to draft a civil law contract in English, for example, a British, like with a British counterpart, if it's UK law, or with an American or Australian, you know, something with common law system, no?
Mm-hmm.
So for example, which contracts do you deal with mostly?
For us, in English, most of the contracts are from non-disclosure agreements and intercompany agreements for the services or the employees who are in foreign. I don't know. In English, well, sometimes for the we are in an industry, we have machines, which are we bought machines with all the technical supply and everything like that. Sometimes we have also contracts, technical contracts in English. So I don't know.
Yeah.
It depends.
Yeah. So yes, for example, with this kind of things, no, because you have technical details in the contracts. This is those are very specific, no, type of contracts that of course involve technical knowledges, but we don't really have to be to know exactly all the technicalities.
Even in Spanish, I don't understand exactly what they say. So
exactly, it's just a matter of putting it in a way that it's understandable, no, for both parties. Also, so having, for example, an issue that relates to this contract is the fact, and this is why I mentioned torts before, because, for example, an area of torts, of civil wrongs, civil liability, is what it's called product liability. So if you know, because this is a consequence of this kind of contracts as well, no? Because there is a concept that also a product can create damage. So we have to know what that means, no? And that implies, of course, this is a universal sort of now discipline. In Europe, is disciplined by directives, European directives, but there is also and they're very similar for example, to the US theory of product liability, but it's very interesting, no, to know what it implies and how you deal with it. Again, not in specific technical details, but just like the basics, so that you know exactly what can happen, and if it happens, how to deal with it.
Yes.
So but for you, I mean, it would be, let's say, more important to be able to express yourself in writing or in like orally?
Well, both, because
Both.
yes, both. Because we have, as I said, We have meetings with people in France in English usually, and we have to write documents in English also. So we have both. Yes.
Okay.
Yesterday I had a meeting about GDPR law.
Oh yeah. Oh yes.
The new regulation about the IA
Yes.
in English. It was a little bit difficult because I've studied the regulation in Spanish, and I have
Yeah.
to express me in English
Yes.
about that thing.
Absolutely. And about the GDPR, now, for example, the policy is to use clear and simple language,
Yes.
because they used to be very complicated to understand. And this is the thing, you want these things to be understood by everyone. But if you write them like that, people don't understand. That's the, let's say, the old concept that, like, whenever we express something legal, it has to be difficult for whatever reason. But it's not like that, because I mean, again, it's not that you have to be informal. Okay, you can be formal, but in a way that is easy to understand. This is why, for example, an exercise that I do with my students all the time is to try, because as lawyers we do that. We have to translate from legal to plain. No? So, for example, let's take this decision. You have to explain it to a client who knows nothing about legal language or law. You have to do that. So you translate it, into plain language, and sometimes you take something plain and you make it formal, because it's very useful to do, because when you have you can talk with very pompous and formal language to somebody. I mean, in my experience, I had so many clients who didn't know anything about the law, and I had to explain everything I did to them. And how would I do that if if I couldn't speak plain, like translate, no? So this is the thing. I mean,
Okay.
this is why I think it's very important to learn to be able to do that, because it's something that we sometimes take for granted, again, because we have so many tools. But practically speaking, it helps you being more confident and more secure, no, in what you do, because otherwise you always have the doubts, like, have I done this correctly? Because it's not your language, and it's always challenging, no, to do something
Yes.
like so. Because we didn't have so much time, I just gave a very general overview of why it is important and what we do in the courses to what the courses are about, and how that can help you in your day-to-day practice. No?
Yeah.
So I don't know if you have any other question. We only have like 2 minutes left, I think, but I don't know if you have any other questions or.
No, it's clear. Thank you.
Yeah,
Yeah.
Was it clear enough, everything?
Yes, of course.
Okay, great.
Thank you.
Thank you.